Hi, and welcome to this video on directors' duties. I'm Tom Harvey, and I'm one of the senior knowledge lawyers in Osborne Clarke's corporate team. In the next 10 minutes or so, I'll explain what the duties of directors are, what the consequences of breaching those duties might be, and some areas to watch out for, including where those duties continue beyond directorship. You can find more information in our Director's Guide, which is available from your usual Osborne Clarke contact, or if you're watching this via a training portal, you'll be able to access it directly through the portal. This video is aimed at directors of a company incorporated in the UK and applies to both public and private companies. The rules are the same for all directors, regardless of their nationality or place of residence, and whether they're executive or non-executive. Although the role of a non-executive director means that the way in which they discharge some of their duties will be different. The statutory duties are set out in the Companies Act 2006, the principal legislation governing UK companies. There are 7 statutory duties, and we'll look at each of them in turn. These statutory duties are supplemented by a couple of other non-codified duties, which we'll also look at. Here they are on the right. In each case, the duties are owed to the company. This means that only the company, which in practice usually means the board, can bring an action against the director for breach of duty. But in order to effectively hold boards to account, shareholders can bring what's known as a derivative action to sue in the company's name. In addition, we see a lot of claims being brought by insolvency office holders following a corporate failure. These office holders take over the management of the company from the directors and are able to bring claims against directors for prior breaches of duty in order to maximise returns for creditors. The law provides for a range of remedies for breach of duty. The most common remedy is a financial claim against the director, including the payment of damages and requiring the director to pay back profits they have made through the improper use of opportunities or other information belonging to the company. Other, less common remedies include court orders to restrain acts which would otherwise be a breach of duty, and the setting aside of transactions tainted by a breach of duty. Now let's look at the duties themselves. The first duty is to act in accordance with the company's constitution and to exercise powers for the purposes for which they are conferred. The company's constitution for these purposes usually means its articles, which are effectively the rulebook for the company, setting out how it is governed and the relationship between the company, the board of directors, and its shareholders. Most articles confer wide powers on the directors to manage the company's affairs, but any limitations on those powers must be respected. The duty to only exercise powers for the purposes for which they are conferred means that directors must exercise the powers they have in good faith for their intended purpose. To take an example, a board which issues shares to a friendly third party in advance of a shareholder meeting to influence the outcome of that meeting would be in breach of this duty, because the power to issue further shares is granted to the directors to enable them to raise capital for their business and not to influence the outcome of a shareholder vote. In these circumstances, the vote could be set aside. The second duty is at the heart of the relationship between a director and their company, and this is the duty to promote the success of the company. The wording of the duty is set out on the screen now. It is quite lengthy and involves quite a few concepts, so let's unpack some of these now. The first question the duty raises is, what is success? When this duty was being written, the UK government said that, for most commercial companies, it meant long-term increase in value, which seems like a pretty sensible assessment. The second element of the duty is that directors must act for the benefit of the company's members as a whole. What this means is that a director can't prioritise the interests of a particular shareholder or group of shareholders over another. This is particularly relevant for directors appointed by an investor. Decisions taken by the investor director must be made in the interest of all members. It's important to note that the law doesn't exist to second-guess the commercial judgment of directors. Provided the director is acting in good faith in the way that they think will promote the success of the company, even if a decision ultimately proves to be a bad commercial one, then they will not be in breach of this duty. The next part of the duty is the requirement to have regard to stakeholder interests, including those of employers and suppliers, and wider societal issues such as the impact on the environment. What this means is that directors need to actively consider these factors when relevant in deciding what to do. It does not mean that the directors need to balance these stakeholder interests against the interests of the members. The language of the duty was specifically amended as it became law to make the primacy of members' interests clear. But promoting these stakeholder interests is likely, in most cases, to be consistent with developing sustainable long-term value, and so linking back to the concept of success that we just talked about. It's worth noting at this point that a director's responsibility to promote the interests of the company's members switches to safeguarding the interests of creditors if a company is approaching insolvency. Whilst we don't have time to cover this in today's video in any detail, the takeaway point is that directors should be seeking appropriate professional advice if there is any prospect of a company becoming insolvent, not least because directors can face personal liability to compensate creditors for continuing to trade when there is no realistic prospect of avoiding insolvency. The third general duty under the 2006 Act is that a director must exercise independent judgment. This doesn't mean that a director must be independent. Rather, when they are acting, they must use their own judgment and not just act as a conduit for example, the directions of an appointing shareholder. The duty does not prevent a director from relying on the advice or work of others, but the final judgment must be their responsibility. The duty is subject to a couple of provisos, the most important being that directors can enter into an agreement which restricts the future exercise of discretion by them. For example, a commitment to do something in the future, provided it is consistent with the board's other duties, in particular the duty to promote the success of the company, to enter into that commitment at the time. The next duty is the duty to exercise reasonable care, skill and diligence. This duty introduces a two-part test to establish the standard of care expected of a director. This first part is an objective test under which a director must exercise this care, skill and diligence that would be expected of a person carrying out the functions carried out by that director in relation to the company. So what kind of behaviour would satisfy this objective test? The courts have said that directors have, both collectively and individually, a continuing duty to acquire and maintain a sufficient knowledge and understanding of the company's business to enable them to properly discharge their duties as directors. Examples of the right things to do would be seeking out information from executives and others and challenging that information if necessary, becoming familiar with the company and its business, including its financial statements, requesting, if necessary, the involvement of external advisors on matters of material importance, monitoring the operation and management of the company, including regular attendances at board meetings, and understanding the commercial, legal and regulatory environment in which the company operates. Because the test looks at the functions carried out by the relevant director, the expected behaviours of a non-executive director and, say, a finance director are necessarily quite different. A non-executive director would be expected to discharge effective oversight over and critically examine the work of the executive team, whereas an FD would be expected to have a detailed knowledge of all aspects of the company's financial affairs. The second part of the test is that a director must exercise the care, skill and diligence that could reasonably be expected of a person with a general knowledge, skill and experience that the director actually has. So looking at the person rather than the office. This is known as the subjective element. So if a director has a high level of knowledge in a particular area or a particular skill set, he will be expected to use that knowledge and exercise those skills in relation to the company. Next, we'll look at two types of conflict of interest which are dealt with by the general duties. Actual or potential conflicts arising between a director's personal interests or duties to some other person and the director's duties to the company, known as situational conflicts, and conflicts relating to an interest of a director in a transactional arrangement with the company itself. We call these transactional conflicts. Different rules apply to each type of conflict. Broadly speaking, directors are under a duty to avoid situational conflicts, unless a relevant exception applies, and a duty to declare transactional conflicts to the other directors. Looking at the first type of conflict, what type of situations would be caught? The legal definition in the Companies Act is extremely broad, and so a good rule of thumb is to think of a situational conflict as any circumstance which could potentially divert a director's mind from giving sole consideration to promoting the success of the company. Directors should disclose any potential conflicts to the board as soon as they arise. Some examples of situational conflicts we often see in practice are where a director is appointed by a major shareholder, where they are a trustee of a company's pension scheme, or where they hold another directorship with a supplier, customer, or even a potential competitor. Broadly speaking, situational conflicts can be authorised by the non-conflicted directors, by the shareholders of a company, or by a company's articles. The rules on authorisation are detailed, so do have a look at Osborne Clark's Director's Guide for further background. The duty to avoid situational conflicts includes conflicts which arise through the exploitation of the company's property, information or opportunity. This means that where, for example, a director becomes aware of a business opportunity in their capacity as a director, that opportunity belongs to the company, and the directors of that company as a whole must be given the option to determine whether the company should pursue it, even if it is outside the company's usual line of business. This aspect of the situational conflict duty, alongside the general duty of confidentiality, survives termination of a director's appointment. So someone resigning in order to take up a business opportunity or divert that opportunity to a new employer, which they become aware of whilst a director, would be in breach of this duty, regardless of the fact that they had previously resigned. There are a number of reported cases in which directors have been required to account for profits made in a new business venture in just this type of situation. Transactional conflicts are usually easier to spot. This is where a director has a direct or indirect interest in a transaction with a company. So they might be the recipient of a share option, or another business venture in which they're a shareholder might be leasing some property to the company, for example. Here, broadly speaking, the director must declare that interest to the other directors so they can make their decision with the knowledge that other directors' interest. The articles of the company will then dictate whether the conflicted director must step aside from consideration of that transaction, or whether they can continue to participate and vote on board decisions. The final statutory duty is the duty not to accept benefits from third parties, where these are paid because of a person's directorship, or to encourage a director to do or not do anything in that capacity. This is a codification of earlier law that directors should not make a secret profit from their position and must account to the company for any profits they make as a result of their position as directors. The duty is not infringed if the acceptance of the benefit cannot reasonably be regarded as likely to give rise to a conflict of interest. The Companies Act does not set out any sort of minimum threshold, and so it will be a question of judgment as to whether this reasonable test is satisfied. But, generally speaking, compliance with standard anti-bribery and corruption policies will usually mean that this duty isn't infringed. Finally, a director owes a continuing duty of confidentiality to the company. This duty isn't codified in the Companies Act, but continues to apply. It's important to note that this duty continues during and indefinitely beyond the termination of office. That was everything we wanted to cover in this introduction to directors' duties. We hope that you found it useful. You can find more information in the Director's Guide or speak to your usual Osborne Clark contact. Thank you very much for watching.